What can that all encompass, these fees?
Well, potentially if you had to hire an agent to do it for you, advertising costs, if you had somebody coming out showing it for you, I'm not sure you could get your time, for showing it. Although if you had that in your contract, you may.
If you're representing another owner, their portion they have to pay, is that covered?
Yeah, possibly. It's gonna vary because there isn't any black and white on what costs and what fees are reasonable, okay? So the more of those you put into your contract with the tenant in the first place, the better off you're in. Those are the type of specifics that I was referring to should be in your contract, right? So in the event you breach, you'll be responsible for X, Y, Z, right? If you put that in your contract, then I think you've got a fantastic chance of collecting it. And if it's like an hourly rate for your time, don't just say, time served or time done or time applied, whatever. Just give up, $20 an hour, $15 an hour, whatever your time's worth. Specify it in the contract. If you've got those kind of details in your contract, you should be golden with regard to collecting them. Okay? Good question. Clearly specify the rental period. I see these a lot. Some very confusing documents generated by some creative landlords. We don't always start something on the beginning of the month. We don't always make the payment due on the beginning of the month, so people get paid different times and there's a lot of flexibility out there. But if you want to terminate a tenancy, it is imperative that you have the rental period accurate. Because the only time you can terminate a tenancy is on the last day of a rental period. We call them 20-day notices to terminate, but that's a bad way. There's a notice to terminate, and it has two requirements. It must terminate on the last day of a rental period. That's the only day it can terminate. And it must have at least 20 days prior to that last day. So a lot of people don't take the steps in their contract to make it clear what the rental period is. Just spell it out. The rental period is from the first of the month to the last of the month. It's not first of the month to the first of the month. First of the month to the last of the month, right? And then if you want to say rents are due on the 5th, or they started their tenancy on the 14th, and rents are due on the 15th. If you want your rental period to be from the 15th to the 14th, so be it, but state it. You're always better off prorating, okay? If you start a tenancy at some other time of the month than the first of the month, and you want the period to clearly be the first of the month to the last of the month, prorate it. Spell that out in your contract that the first month's prorated, or take the first month's rent and spell it out that the second month is prorated, okay? If you insist on taking the first month's rent up front. Right, but make sure the period's just clearly spelled out, because that can bite you. That's an easy defense. I could go in on a number of times and say, well, wait a minute, this says the rent's due on the 5th, and therefore the period should be the 5th to the 4th, and they've terminated it on the wrong date. That's going to be an issue of fact that gets me to trial. If I'm working the other side. So, yes, ma'am, you had a question? You do not have to give any grace period for late fees. I see that frequently where it's worded confusing too. It's very common for people to say rents are due on the 1st, but there's a late fee after the 5th, for example. Those are the two most common dates. Frequently, though, it's worded poorly, and you end up, because of that ambiguity, ended up having to give them to the 5th. And then you're instantly in an argument about what the rental period is. Right? So no matter what you do, whether you pick the 1st or whether you pick the 5th for your rental period, for example, to terminate, the other side can make an argument. Doesn't matter. Whichever one you pick, I'm going to make an argument for the other one. And that's my ticket to a trial, and suddenly you're in a bad bargaining position. Right? Well, the grace period's fine as long as you make it very clear. The rental period is from the 1st of the month to the last of the month. Rent's due on the 1st of the month. If it's not paid by the 5th, there's a late fee. As long as it's worded clearly, There's a question back here as well. Yes, sir.
I had two questions. One, lots of times I run into a situation, I like to use one-year leases, and the problem is it's in the middle of the month. So I'm forced to rent it for 11.5-month lease because of the one-year restriction without having notarized signatures and that type of thing on the contract. It would be nice if the state law could be changed to allow up to like a 13-month period for a lease period, so you could do a 12.5-month
Well, that's
lease situation.
the statute of frauds, and you can do a 12.5 months. All it requires is that you notarize it. You don't have to comply with the statute of frauds, you don't have to have the tenants notarize it. It's only required to be notarized by the landlord.
The second question I had was, I just recently got insurance renewed for one of my properties, and there's an exclusion if the tenant grows marijuana. All coverage for me, the landlord's excluded, if I have a tenant that grows marijuana, distributes it, or provides it to others. And likewise, you could go through all the screening you want to try and prevent people from moving into your complex, but once they're there, with the just cause eviction notice law in the city of Seattle, and what kind of recourse do you have?
Illegal
for
drugs are just cause, and it is still illegal under federal law.
Right,
And I absolutely go after people for marijuana all the time. I
so
don't
then you have to go to
hesitate.
federal court?
No, you don't. You have a crime-free addenda that says the tenant agrees there shall be no illegal drugs. Federal, state, it's not just drugs. No crimes committed under federal, state, or local, county, and city ordinances. You put a crime-free addenda that covers all that, and you evict based on them violating that crime-free addenda. And I do it frequently, and I haven't had anybody call me on it yet, and I'm going to keep doing it. A court can't, I can't see any legal theory where a Washington state court could invalidate a breach of contract when they have agreed not to break federal law, and they are breaking federal law.
So the just cause, City of Seattle just cause ordinance wouldn't stop you?
I don't think if you've got that crime-free addenda and it's worded properly to include federal law, don't break any laws, federal included, their crime-free addenda, their just cause ordinance still allows for drugs. So, I haven't seen anybody get called on it yet, quite frankly. It may be coming, but, yes, ma'am?
Where do you obtain a crime-free addendum?
Well, we've got one on our website. I know RHA provides one. You can go to, frequently the police departments, local police departments have crime-free addendas that they'll hand out. A lot of time they've got the neighborhood watch or crime-free programs, so you might want to start there as well. Let me go back here first. Yes, ma'am?
We have a crime-free addenda in our building, and we also have we went to the efforts of having a non-smoking property.
Yeah, that's another good one.
Non-smoking property supersedes the crime-free, technically.
I'm not sure what you mean by supersede. They both should apply.
Both will be applied.
Right, but in the situation that the gentleman was talking about where they're growing or distributing, that's not necessarily smoking,
No,
right? So you've got, your two addendas cover you, there's like 20 some odd ways to use marijuana that don't include smoking or something like that. So they're both viable. That kind of nonsense can do a ton of damage to your property. And you have every right, in my mind, to for as long as it's forbidden, smoking for sure, and as long as it's still against federal law, I don't hesitate. But the crime-free addenda helps dot the i's and cross the t's, because then you're explaining to the court they violated the contract where they agreed not to violate federal law. This has nothing to do with Washington State. Yes, ma'am.
What type of documentation do you need in order to prove as a landlord?
Typically for drugs, if you've got, the police officer has reported to you, if you have word from a police officer or a letter from a police officer or some sort of report, that'll do it. But you could also use your own, what you've seen, experienced yourself. It might be smell. Then you have to explain how you know what it smells like. You might see a grow operation during an inspection, or maybe some other witnesses. which you might need declarations, so there's a number of different ways. But remember, the burden of proof is just more likely than not, okay? I realize we're talking about a criminal activity, but your burden of proof is not beyond reasonable doubt. It's just more likely than not that it's happening. Okay, and if a police officer, for example, has made an arrest, they've got probable cause, they've met your burden. But there's a number of
If you
scenarios.
had neighbors for like a single family home, if you had neighbors calling you about the traffic,
Traffic is it's tough, okay? High volume, short-term traffic is one indicia of activity. I don't know that I'd rest my hat on just that. All right, I'm gonna move on here real quick. If there's more questions, we can turn to after. We already talked about any period more than a year needing to be notarized by the landlord. Be careful, I see a lot of people say, this contract's good from 1st of May 2014 to 1st of May 2015. That's not a year, that's 366 days, right? That's a technicality, but I've frequently seen technicalities bite landlords in the backside big time. Non-waiver clause, you want to have a non-waiver clause. A lot of times these days, especially economy's so bad, people are moving in together, there's short payments, there's late payments. Landlords aren't looking for vacancies, they work with their tenants. You can work your way right out of the ability to strictly enforce your contract. A non-waiver clause protects you. So if you've taken 3 or 4 or 5 late payments and you decide, I'm done, got to pay it on time now, or normal partials, that non-waiver clause is what you need in your contract. Otherwise, the tenant can say, wait a minute, we've modified our agreement by a course of performance, and they're right. And you may not ever be able to enforce the deadline again. Yes, ma'am?
Can you add a non-waiver clause when you renew a lease?
You can. Or if you have a month-to-month, you could do a 30-day rule change. In either case, you do a 30-day rule change, 30 days prior to the initiation of a new rental period. That might be at the end of the lease, or it might be month-to-month, each month. And they don't need to sign it. You can do it unilaterally as long as you do your rule change accurately. Yes, ma'am?
Could you give an example of wording for a non-waiver clause?
Off the cuff, I'd say the landlord's failure to strictly enforce any term or clause in this contract shall not constitute a waiver of the landlord's ability to strictly enforce in the future. Something along those lines. Yes, ma'am?
I was just wondering about application, so if you have a contract that's very clear, but a previous, like property manager, for example, has not been enforcing, and saying, and then there's multiple people saying, this was never enforced, why are you enforcing it now? Is it required, would you then want to do a non-waiver to protect yourself?
If you had a non-waiver in the contract, you're already protected. If you didn't, then what you need to do is do that 30-day rule change at the end of whenever that contract ends, whether it's month-to-month or a lease, and change the law to include, or change the contract to include a new non-waiver clause. Okay. Check that you don't inadvertently give more notice requirements to your tenant. We talked about that briefly. I won't spend much time. Contract can act, 30 days, pay or vacate. We've seen those. Be careful, you know what your contract says. Your deposits. You may not keep a deposit for damages. If some of that deposit can be retained, you cannot keep those unless you give proper the information that the tenant's entitled to in your contract. For damage deposits, you must have an initial walkthrough inspection, initialed on every page by both parties, not just them, both parties. You also have to indicate what bank and branch that's going to be kept at in trust. You need those things or you can't keep a deposit, okay? Now, security deposits, I would say treat them the same way, other than if it's strictly a security deposit separate from a damage deposit, then you're obviously not required to have a walkthrough for security. If it's a combination of damage and security deposit, then I would have a walkthrough for sure, or you won't be able to keep it. Okay? Addendas, you've got a number of addendas required by state law here. We offer them on our website as well. You've got to have the mold addenda, smoke and CO, hot water tank, and lead paint. Okay? Those are all addenda that are required to be part of your contract under state law. With the lead one, I'd say, with the mold one, be careful. There's a lot of people use the mold handout from the EPA. That's federal, okay? There's one required under Washington state law by our health department. That's the one you want to use, okay? I mean, you could use both, but I'm not a big fan of confusing the issue, but our law requires that you use the Washington state one, okay? So you go to the health department, they have it, you can print it off there too, or you can get it off of like our website. If you're a member, we give forms out for free. Or I imagine RHA has something similar as well. Make sure your contract includes completed walkthrough. We talked about that. Don't shortcut it. I hate to check the boxes, okay? I like to have stuff you have to fill in. It's not enough just to say, okay, fair, good, whatever. Make notes on everything, right? You walk in and someplace looks good and you just say good. You shouldn't do that. You should say checked for mold, no mold found. Checked for, leaking window seals, no leaks found. Blinds in good shape, whatever. Put the positives in there as well. Let them know that you looked for the individual things. Spend 2 hours if you have to going through it and documenting it before they even get there, okay? Don't shortcut this. And there was a case that we've been fighting for the last couple of years called Landis. One of the things that came down in this case was that on any given day, a walkthrough may be of limited value. So what they did is they just pulled the rug out from underneath us on how important this can be, okay? So, or how protective it can be. You need to make sure you've got as much detail in there as you can. And what I recommend, what I consider to be best practices now, I have put in my contracts that the tenants are going to return another walkthrough, initialed on every page, filled out by them within 7 days of having occupied the premises as a material condition of the lease. If they don't do it, I 10-day them and I'll evict them for it, right? Because then you've got two separated in time after they've had a chance to live in it a bit, and if you have to go into court and argue about some of this stuff, you just got bulletproof, more or less. Okay, nothing's bulletproof, but it's certainly better. Yeah, let me go back here, Robert.
When can we use video documentation in the future? Where do you see that going? Is going with the tenants there in there with us, recording the actual event of the signing?
The video documentation is going to depend on the individual court and their court rules and what they allow. Typically, I don't know of any court that's going to allow that at a show cause hearing. So if you've got to argue about that, you may end up at trial. But mostly damages aren't dealt with in unlawful detainers anyway, so you're probably in a small claims trial if you're dealing with damages, or probably a district court trial. So the rules about video evidence are going to vary based on the jurisdiction, so I can't give you a blanket answer. But you should be able to look up the local court rules in Lewis County, for example, and find those and be ready for it. Pictures, you can always use pictures. Every court will accept pictures, digital, but videos, hit and miss. Yes, ma'am?